So hello all, I hope you guys are all well and having a great week. Tonight, Middlesex University Product Design Engineering and Design Engineering are really excited to host our 11th talk in the annual guest lecture series. So this series runs weekly throughout the academic year on Thursday evenings, bringing together a vibrant mix of speakers from across the full spectrum of design and engineering, a mix of leading practitioners, opinion leaders, radical thinkers, and emerging talents to inspire and support the professional development for all of our participants. Tonight, we're really excited to host Philip Slingsby, Anna Bools, and Verity Andrew, the partners and patent attorneys of Slingsby Partners. They're familiar faces in our faculty and department. They delivered a really well received guest lecture last year, alongside running superb IP workshops for the final year students as well on the BA Product Design and BA Product Design Engineering programs. So who are they? I'm Philip Slingsby. He's a patent attorney and the managing partner of Slingsby Partners LLP. He specializes in obtaining protection for inventions and designs. And he also advises businesses and designers on how to maximize the value of the intellectual property. In addition to his work on securing IP, he has 25 years of experience in license negotiation, and he represents clients in intellectual property disputes, both in the UK and internationally. Anna Bools and Verity Andrew, they're both part qualified patent attorneys. Anna Bools, following the completion of a physics degree at the University of Exeter, joined Slingsby Partners as a trainee. She's been in the profession for almost 4 years and has experience prosecuting patent applications in a variety of countries. And she's particularly experienced in the fields of graphics processing and healthcare technology. And Verity Andrew, she joined Slingsby Partners as a trainee in 2020 during the COVID pandemic. She has a physics degree from the University of Bristol and recently became a part qualified following the completion of a postgraduate certificate in IP law at Queen Mary University of London. As usual, guys, feel free to gather your thoughts, your questions, your comments in the chat throughout the talk. We'll have Q&A at the end as well, and there's also the option to go live and interact with our guests after the main talk. And without any further ado, over to our guests, Anna, Verity, and Philip, with the talk titled Intellectual Property for Designers.
Hi, everyone. Thanks very much, Ahmed, for the introduction. And can everybody hear me, by the way? Is that a yes, Anna?
That's a yes. That's a yes.
Okay, great. Yes, good afternoon, everyone. And thank you, Ahmed, for inviting us to give this lecture for a second year. Last year, Anna and I did this, and as you say, we're joined by Verity this year. We really enjoyed presenting the event last year. A highlight for me was the discussion at the end. I was really excited to learn a lot about the projects that people are working on. And there were some really great questions about some practical intellectual property issues that people had faced as designers. So we're going to leave plenty of time at the end to run through questions, and I'm hoping we'll have plenty of them to answer. Just on the format of the lecture, we're going to present some slides about different intellectual property topics for about 40 minutes, probably. There's going to be a quiz at the end, and that should leave us plenty of time to answer whatever questions people might have. We had been intending to do a bit of an introduction ourselves, but Ahmed's beaten us to it, and I'm not sure I can do a better job. So I think maybe if I hand over to Anna to present the first few slides, that's a good place to start.
Thank you. Yeah, so as Ahmed has said, most of what we do is focused around advising our clients as to how they can best protect their designs and inventions, and sort of organising getting that protection for them. And the aim of this presentation is to give you a brief overview of what intellectual property is and how it might be relevant to you as designers. So what is intellectual property? A dictionary definition of intellectual property is an intangible creation that's a result of human creativity. So basically ideas rather than tangible things. That might be an idea contained in words, a logo, images, or in your case, an object or product, probably most likely. The law provides a number of mechanisms which you can use to protect these sorts of ideas. And sort of protection in this sense means you can stop other people using your idea, basically. So in the UK, the main types of intellectual property protection are copyright, trademarks, patents, and design rights. Before I started doing this job, I didn't really know what the differences were between all of these things. And it's definitely a useful thing to know for general life, and especially if you're a designer. So just taking this McLaren car as an example, the design of the appearance of the car will be protected by a design right. So basically anything looking like this will fall under the scope of protection of that right. And as well as the design of the overall car itself, it's likely to have other design rights for smaller parts of it. So it might be the look of the headlights or the wheel or any part. So the thing to sort of note here is that protection doesn't need to apply to the whole article. It can be to smaller parts of it. Then the McLaren logo will be protected using a trademark. Patents will be used to protect inventions within the car. So again, that's not likely to be a car per se being the invention, but it will be smaller parts of the car, which McLaren have sort of come up with and invented. And there'll probably be, tens to hundreds of patents to different components within this car. And then copyright can be used to protect literary, dramatic, musical, and artistic works. So of those, the most applicable here is probably copyright in the literary work that's in the owner's handbook. So that'll be sort of the text itself within the handbook. So first we're going to go into a bit more detail about what copyright is used for. So as I said, it protects literary, dramatic, musical, and artistic works. So books, paintings, songs, dances, films, etc. Copyright protection arises automatically. So that means as soon as you've made your film or written your book, etc., you own the copyright in that thing. You don't need to sort of apply to an external body to grant you that protection. It arises automatically when you've made the thing. And there's no need to register that right with anyone. The protection afforded by copyright means that the owner of the copyright, who is the person who first creates the work, so that might be the author, a composer, etc., they can stop other people using their work by enforcing their copyright protection. Someone who is using your work or copying your work is said to be infringing your copyright. And if you really wanted to enforce the copyright, you could take the infringer to court. The length of protection of copyright lasts, for literary work, the lifetime of the author plus 70 years. So when that 70 years is up, the work is out of copyright and it can sort of be used freely by everyone without infringing. So taking this book as an example, copyright will subsist in the text or the story within the book, and that will be owned by the author. Copyright will subsist in the cover art because that's an artistic work, and that will be owned by the illustrator. The typographical arrangement is another type of artistic work. So that's sort of how the text of the book is laid out. And that will be owned by the publisher. And then were that book to be made into a film, the film itself has copyright attached to it, and that is owned by both the principal director and the producer in most cases. The film script is a literary work. So sort of the text itself of the script will be owned by the script writer. A film poster is obviously a sort of artistic work, so that'll be owned by the designer of that poster. Film score will be owned by the composer, and the soundtrack by the soundtrack producer. So as I said before, infringement is use of someone else's work that's under copyright, basically. So an infringing act could be reproducing the work, storing it, communicating it to the public. That's sort of the reason why pubs, for example, can't just show films to their patrons because they don't have permission of the copyright owner to communicate that work to the public. And infringement doesn't need to be necessarily that you're using all of the work. You can still be said to be infringing if you're using a substantial part of it. And so there's sort of lots of discussion of what a substantial part means as to how much of the work you can use without infringing. In one case, an 11-word snippet of text was said to be a work and therefore protected by copyright. So the thing to consider here is whether you've copied a substantial part of it depends more on the quality of the part you've copied than how much of a work you've actually copied. And the test is the thing you've used or copied an expression of the author's intellectual creation. So in this 11-word snippet example, the 11-word snippet was sort of so non-generic that it was considered to be part of the author's own intellectual creation. So generally speaking, the more abstract and simple an idea, it's unlikely to be original and therefore unlikely to be considered the author's own intellectual creation. And so copying that simple and abstract part would be less likely to be considered infringement. There are a few defences to infringement. So these include private study and teaching. So if you're using someone else's work for your own private study, education, or in a lecture, for example, that'll be a defence against infringement. But there are usually a few caveats to this. The first is that it's sort of good practice to acknowledge that the work belongs to the author. So don't make out that you've come up with this film, painting, whatever. You need to sort of make sure you're making it clear that it's not your own work, and tell people whose work it actually is. And then another caveat is fair dealing, which basically just means that your use of the work isn't having an effect on the market of the original work. So, for example, me showing you a film poster of Harry Potter isn't going to be having an effect on the film market of the original Harry Potter film. We're not competing against them. And then another thing to consider is how much of the work you're taking. Usually, if you're taking all of the work, that's not considered fair dealing. So if you were making a video and you wanted to use a song in the background, an entire song, even if that was for sort of private reasons and you weren't going to be showing it publicly, it's probably a good idea to get permission from the copyright owner. So there's a few ways to do this with a song. There's websites which enable you to buy licenses. So by buying a license, you're getting permission from the copyright owner to use that song. And it's, well, on this website, we found that it was about £6 a song. So it's quite affordable if you are planning to make a video and you need a song in the background. So next we're going to talk about protecting brands. Verity is going to take over.
Thanks, Anna. Yeah, so another type of intellectual property that's used to protect brands is a trademark. So that's on the screen is a whole bunch of trademarks that you probably recognize. Yeah, and so a trademark is any sign that you can use that works as something that distinguishes your product or your service from somebody else's. So the Apple logo, for example, if you buy a phone with the Apple logo on it, you know that it's come from Apple. You expect it to be of the quality of other products that you've had from Apple, and that's all taken from that logo. So unlike copyright, generally trademark protection doesn't just arise automatically. So to get the best protection, usually you would file an application to register your design as a trademark. And the aim of registering your mark is to prevent other competitors from using it. So if somebody sold a phone with the Apple logo on it and it was a fake, if you had that logo as a registered trademark, you could sue them for confusion and taking away Apple's business, because not only have they lost business from somebody thinking they were buying an Apple product, but they were actually buying a fake. They've also probably had their reputation damaged, because say you've bought this phone thinking it's an Apple product and then it turns out to be rubbish, you're going to then think that Apple's quality isn't as good. So Apple have then had their reputation damaged and they've lost their sales. So you would want to sue whoever made this pretend Apple product with your registered trademark. A sign in terms of trademark signs doesn't have to be a logo. So it could be a slogan, like should have gone to Specsavers. It could be shape of a product. It can even be the color of a product, like the Cadbury's color on a chocolate bar. Usually, if you wanted to trademark a shape, that shape would have to be really intrinsically linked with your product, and you'd have to really know that when you saw that shape, you need to know where that product came from. So, for example, if you bought a Toblerone, and let's flip to the next one. Oh yeah, actually, sorry, I should mention, you can renew your trademark every 10 years. They actually don't expire as long as you keep paying the fees for them, unless they become generic. So, for example, Hoover, the vacuum company, they did have a trademark for their name Hoover, but because they were so successful, everybody then started referring to their vacuum cleaners as Hoovers, and so then their trademark Hoover it sort of stopped being as meaningful. You wouldn't necessarily know if someone's called their Hoover a Hoover that it came from the factory Hoover. So in that case, their trademark has sort of lost its meaning and became generic. But provided your trademark continues to serve its purpose of distinguishing your product from another product, then it will kind of last indefinitely, provided you pay the fees. Yeah, so this Toblerone shape, going back to shapes of trademarks, just through looking at that shape, you know that that chocolate bar comes from Toblerone. You don't need to be told that it's made by Toblerone. So in that case, the shape of the chocolate is doing its job in telling you where it comes from, and so it's serving a purpose as a trademark. So that's trademarks, and now Anna's going to move on to patents.
Thanks. So yes, patents are used to protect inventions. And the process of getting a patent granted is quite long and complicated. But basically you file a patent application at a patent office, and that application describes the invention in a lot of detail. And then that application is examined by someone at the patent office, and they sort of look through it and decide whether they think a patent is should be granted to your invention or not. If the patent is granted, it gives the person who filed the application the right to stop other people from using their invention. But it only gives you that right in the country in which you filed the application. So if you file a patent application and get it granted in the UK, but your competitor makes the same thing in France, you can't do anything about it because your granted patent only gives you the right to stop people making it in the UK. Something to note is that with regards to all of these types of intellectual property, you don't need the protection to sort of give you the right to make the product or sell the product. You have that right, but it does give you the right to stop other people doing it. The main requirements for a patent to be granted are that the invention is novel and inventive. So novel just means that the invention's new, so no one else has come up with it before. Obviously, you can't have a patent for something if someone else has already invented it. And sort of crucially, it needs to be new over everything that's been made public up until the day you file your application. And that includes disclosures you've made yourself. So disclosures made by the inventor. So basically, if you've come up with an invention and you're planning to file a patent application for it, it's very important that you don't make that idea public yourself before you file that application. So, for example, don't post loads of pictures of it on the internet. Don't talk about it publicly in front of lots of people. Because when you file your patent application and it goes to the patent office, they'll then sort of cite those disclosures back at you and give them as reasons as to why you can't have your patent, because it's no longer new because you've told everyone about it. And then being inventive just means that the invention wouldn't have been obvious to someone working in that field. And yeah, it's a bit more of a complicated question. The patent lasts 20 years. And after that, sort of the technology is free to use by other people. So as to the question of when to file a patent application, so sort of what sort of thing should you be filing an application to? It helps to think about an invention as something that has been designed to overcome a problem. So, for example, if you're making a desk which has drawers in it, and you've come up with a new runner for those drawers that means that they open and close more smoothly, you could file a patent application to protect the runner because it solved a problem in terms of it makes the drawers smoother, or just the component of the runner which has the effect. So you don't need to be filing a patent application directed to the whole desk. It can just be relating to that small component, which is the inventive bit. The benefit of that is that then if someone else uses that runner in something that's not a desk, your protection extends over that product and it's not just applicable to people making desks. So just quickly, there are a few things which you can't file or get a patent granted for. Generally speaking, patents can be only granted for things which are technical and tangible. So here, you can't get a patent granted for a discovery, scientific theory, or mathematical method, basically because they're not tangible things. A literary, dramatic, musical, artistic work, or another aesthetic creation, that wouldn't be deemed to be technical, so you can't have a patent for it. And as I was talking about earlier, that is protected by copyright, so there's sort of no overlap between those two things. A scheme, rule, or method for performing a mental act, playing a game, or doing business, or a program for a computer. Again, those things are sort of not tangible, not having an effect in the real world, so they are also excluded from patent protection. And presentation of information, again, I think that's more of an artistic work and sort of regards the look of something rather than how it actually works. So that would be more, that would fall into the copyright protection category. The process, as I said, of getting a patent granted is quite long and generally expensive. So initially, the drafting of the patent application, so that's like a detailed description of how the invention works, has a cost attached to it if you get a professional to do it for you, which is advised. And then when you file your patent application at a patent office, that has a cost. Then the patent office will perform a search. So they'll look for everything that's been made public around that topic before, in order to determine whether your invention is new or whether someone else has already come up with it. And then they sort of use those documents to examine the application. And this process can last sort of up to 4 years from when you've first filed your application, and sort of incurs costs along the way. And then finally, if they've decided that your invention is patentable, it might get granted about 3 to 5 years after you initially filed it, which has a small cost associated with it. And then once it has been granted, in order to keep the protection going, you have to keep paying fees every year, which increase as the time passes, up to the 20th year, at which point your rights cease. So I think now Philip and Verity are going to talk about the differences between patents and designs.
Yeah, so I think this one's me. So patents, and the first thing to say about designs is that, as Anna said at the outset, designs protect the appearance of a product. So what it looks like, irrespective of how it works or what it does. So going back to Anna's example of a car, you could have a registered design for the shape of that car, and that could stop people selling toy cars or cakes in the shape of that car, or you know, any other product that has the same appearance, irrespective of what it actually does. Whereas patents, the purpose of a patent is to protect how something works, and they do that irrespective of what the product in question looks like. So if you have a patent for you know, the mechanism inside some part of the car, then that patent would be infringed by someone who makes or sells that same mechanism in a very different product. You know, maybe it might be part of the door lock, and it could still be infringed if the invention is used for the door lock in a house, for example. And the way that patents and designs protect or kind of define the scope of their protection is quite different as well. For patents, each patent will have one or more what are called claims, and each claim is a short description that encapsulates what all the features of the invention are. We'll give an example in a few minutes just to illustrate that a bit better. Whereas to protect design, you typically put together a set of drawings that illustrate what the design looks like, a bit like the one that Anna showed earlier in relation to a car. And those design drawings give people an idea of what the scope of protection is. And in both cases, you can get protection for part of the object as well as for the whole thing. So there might be a distinctive wheel, for example, on the car, or there might be an aerodynamic element that's underneath the car that you can't even see that you could protect with a patent. One more thing to say, which Verity will talk a little bit more about later on, is that there are two types of protection for designs. When I say we protect the design or define the scope of protection using images, I'm talking there about what are called registered design rights. And to get a registered design, you need to file an application with the patent office in a similar way to the way that you get a patent. Verity will go on to explain that there's another type of design protection which arises automatically without you needing to file an application. So if you go to the next slide, Anna, we've got some examples of this distinction between patents and designs. And the examples are to do with this bedside crib that you can see on the left-hand side. So on the left-hand side is a photograph of what this product looks like. It's a clever kind of crib that you can fold up and put in your car if you're going traveling, and then you can clip it together, and you can move it up and down to different heights, so it can be next to your bed or next to a chair. And on the right-hand side is a picture of the kind of drawing that you would use to protect this with a design. So this picture illustrates a couple of things. First of all, it illustrates that the scope of the design is defined by this drawing and not some kind of written description. And secondly, you can see that some parts of the crib, the fabric parts, are missing in that registered design drawing. And the reason for that is that those fabric parts are to some extent flexible, and they could take a whole range of different shapes. So what we've done is to remove the fabric parts and just protect with the design the rigid parts that give the thing its overall structure. So the drawing on the right is what you would use to protect a registered design. And if you could go to the next slide, Anna. Oh, and I missed out a registered trademark. This, which is the name of the crib. And then on the next slide, this written description down the right-hand side is an illustration of what a patent claim might look like. So you can see that, I'm not going to read through the whole thing because it's quite involved, but you can see that it's a quite precise written description of some technical features of the product. In this example, it's to do with how the leg mechanism retracts and extends and folds up. And the point of having a claim like this is so that when we want to assess whether someone's infringing this patent, we can compare in a very precise way what their product is with what the features that are defined in this claim are. So a patent typically has a more precise scope of protection than a design does. And as patent attorneys, we can do more to influence the scope of protection of a patent because we have to write these words, and we very carefully choose the words that give us the broadest scope that we think we can get. So on to the next slide. I think, am I right in saying that you're doing this one, Verity?
Yep. Yep. So yeah, as Philip mentioned, a design is for the appearance of a part or the whole of a product, as opposed to a patent. And there are two main ways of protecting your designs in the UK. The first is an unregistered UK design right. So an unregistered UK design right arises automatically, similarly to copyright, in that you don't have to do anything. As soon as you've made your design, you have an unregistered design right over that. This is specifically for designs that are not commonplace. That is just kind of there to avoid you trying to claim that you've designed something that's really standard and that really obviously already existed and there wasn't much, you haven't added anything to it. So the commonplace part is quite a low bar. And also, because you can have a design in any part of your product, it may be that it's a very specific part of your design that is going to have this unregistered design protection. It might not be the whole thing. So an unregistered design right is specifically to protect some against copying. So you might have got, it's not the same as a registered design right, which I'll talk about in a minute. It's specifically for protecting things that somebody has copied. So generally, if you wanted to use this right, you'd need to have some evidence that you had got your design, that you had made your design and when you had made it, whether it's a photograph or some design drawings that you have. You'd need some kind of record to say when you created this design. And once you've got that record, you will have an unregistered design right for 15 years from the creation of that design. Or if you've marketed it within the first 5 years, it's then you have 10 years of protection. So overall, you'll have 15 years of having this unregistered design right. That's just automatic. Any on creation of your design, provided you can show that when you created it, that just arises automatically, and that only protects you against somebody else copying your design, and that can be proven. So you might be thinking that how on earth are you going to prove that somebody's copied your design? But if you sent them an email, here's my new design, and then the next day they kind of made one that looked exactly the same, I think you'd have quite a good argument. So yeah, that's just arises automatically and lasts for 15 years. There is another type of design right called a registered design right. So similarly to applying for a patent at the UK IPO, you can apply for a registered design. So in order to apply for a registered design, you do need to have a new design. So you can't, you won't be granted a design for something that already exists. And there are two kind of criteria that are how they decide whether you can get this right granted, and that's whether it's new and whether it has individual character. And as it says on the slide, you do need to get a different protection is per country. So if you wanted to protect it in another country, you need to apply somewhere else. So this provides, as opposed to unregistered designs, where you would need to prove that somebody had copied your design, a registered design, you don't need to prove that anybody's copied anything. It's just provides you with absolute protection. So it's easier to enforce. You don't need to try and make some argument that somebody copied your work. So a registered design lasts up to 25 years, as opposed to 15 years, which is the unregistered design. And the two you have to have a individual character, and it has to be new for you to be able to get it granted. So the process of getting a design is much simpler than the process for getting a patent, and it's much more affordable. So as I mentioned, you'll need to, for a registered design, you'll need to apply at the UK IPO with your design. So that's probably going to be pictures of your design or maybe drawings, rarely text, unlike a patent application, which will have some drawings in it, but it's written and very detailed. A design, like Philip said, is just just the appearance of it. So you'd submit some drawings or pictures, and it's £50 for one design. You can file multiple designs within the same application. And then that will get looked at by the office. It's really quick. It's not nearly as slow as patent applications, which take months or years. And it's usually much simpler to resolve them as well. So the design's either granted or not granted within 2 months. You can kind of argue about why you think it's novel and has an individual character. So there can be a bit of back and forth, but it's generally much quicker and simpler to get a design. And then once you've got that design, you'll need to pay renewal fees every 5 years, which are £70 for the 5th year, and they go up as you keep it for longer. So overall, it's much cheaper to register a design. And although you don't have to register your design because you have got this unregistered design right that just arises automatically, we would recommend that if you did have a design that you wanted to enforce, it would be more straightforward if you applied at the UK IPO to get a registered design. It's because it's better, much more easier to enforce, and it's not too expensive. So I thought it would be helpful if we gave you some examples of designs where people have infringed and where they haven't. So on the next slide, we've got pictures of 2 different products, and the design on the left is a registered design. That's P&G's air freshener can. So that's a drawing from their design application, and that's registered. So you don't have to prove copying to enforce it. And then on the right hand side, we've got Airwick's version of their odour spray. And this went to the courts, and they were sort of deciding whether these 2 designs were different or whether the Airwick design infringed the P&G design, which is the registered one. And it was concluded that these designs were sufficiently different. So actually, even though you might have thought these look quite similar, it was decided that Airwick design does not infringe the P&G design. So the kind of overall impression that you were getting, the user was getting, would have been different. Like those differences between them would amount to an overall different impression. And I think that makes sense because although they both have the cylindrical shape, I would say that the tops of those bottles are quite different they're not going to be wildly different, but different enough, I think, for you to be able to recognize it. So that's an example of how the designs might initially look quite similar but be decided to be different enough for there to be no infringement. On the other hand, if you go to the next slide, we've got a registered design for an ice bag. So this is a Gimex ice bag design. So this is another registered one. So again, you don't need to prove copying. You've registered it, you've submitted your drawings, it's been granted. And they were trying to sue Chili, the Chili bag, for infringing their design. So these 2 designs for holding wine bottles, to me, they look basically identical. There is a difference in that little label in the top left hand. On the registered design, there's a kind of label so you can put who owns it, but they're really, really similar. And it was decided that they gave the same overall impression on the informed user. So the informed user is someone who uses wine, uses bottle chillers, so maybe a waiter or something, and they, from their point of view, these two products were very similar, didn't look different enough. So the chili bag was held to infringe Chemex's ice bag design. So that was just an example of how actually you can, well, to infringe someone's design, it has to be very, very similar. But it is about the overall impression on the informed user. There are some defenses for using somebody's design, like Anna mentioned with copyright, for both registered and unregistered designs. If you're using design for your private use, private and non-commercial, there's no trouble there. Educational purposes, so teaching like this is fine. And it's also, you do have to remember that with unregistered designs, you do have to show that it's been copied for it to be infringing. So that's another kind of step away from it being likely that you're infringing someone's design. So yeah, that's kind of the overall look on types of design protection you can have in the UK, and how similar they can be without infringing. And I think Philip's going to mention ownership now.
Yeah, thanks, Verity. I just wanted to pick up on one question that Ramsey has put in the chat, which was closely related to your slides about design infringement. And Ramsey's question was, how similar do trademarks need to be in order for there to be infringement? And the test is quite a similar one to designs. So with designs, like Verity said, the question is that something will infringe a design if it makes the same overall impression of an informed user. And with trademarks, it's a similarly kind of subjective test, but the test is whether someone who would be buying those products would be confused about the source of the products if you put the potentially infringing trademark on them. And because the test is framed in that way, the infringing trademark can be more or less similar to the registered one, depending on what types of goods they are. So if they're things that people just go into a corner shop and buy in a hurry, then they'd probably be quite confused, even if the two trademarks were fairly dissimilar. But if it's a really expensive piece of industrial machinery that's costing hundreds of thousands of pounds, then probably they're not going to get confused about the trademarks unless they're very, very similar. So I'll go on to this slide now. So we've talked about what kinds of intellectual property there are, but it's very important to understand who owns the intellectual property, and especially for you as designers, it's really important to know who owns it at the outset, because you don't want to be in a situation where you find that you developed something, but someone else holds the IP in it when you don't want them to. And the rules about who's the first owner of intellectual property are different for different types of IP. And they do depend a bit on the circumstances and where the design was made and things like that. So, but as a general overview, for patents, the first owner is normally the person who invented the invention, or if they invented it in the course of their employment, it will be whoever's employing them. And similarly for designs, it's normally the person who made the design, or if they made that in the course of their work, it'll be the person who employed them. Trademarks are a bit different, because trademarks are for the purpose of identifying the source of some goods. So the owner of a trademark is, generally speaking, whoever's using that trademark, because by using it, they're developing in the marketplace a connection between them and those goods or services. And then finally, for copyright, the first owner of copyright depends on the type of the work, but generally it's the person who made it. And so that is different from patents and designs, for example, where you can have a situation where you've, for example, in copyright, you've commissioned a work, and often people think that by commissioning a work, you would own the copyright in that work, but it's not automatically the case. Generally, the person who made the work in the first place will own it first. But, and this goes back also to another question that was in the chat, once one of these rights has arisen and it's owned by someone in the first place, then that person can transfer the right to someone else. So you can give it to someone for free if you want, or more likely you can sell it to someone. And you can also, so by selling it, that's an assignment. And you can also license the IP. So licensing is where you retain the ownership, but you allow someone else to use it, sometimes by paying you a royalty. Whereas on an assignment, you transfer the ownership to someone else, and then they can then use it without paying any royalties. A further point that we thought it was worth mentioning is just to talk about disclosure. So we have mentioned at least once already that in order to get a patent for something, the invention has to be novel at the time you file the patent application. There are a few exceptions to this, but generally that's the rule. And so it's absolutely vital that if you want to get a patent for something, it must be confidential at the time that you file the patent application. So, it mustn't have been made available to people publicly at the point when you file the patent application. So if you have something that you think you might want to get a patent for, then it's important to speak to a patent attorney before you disclose the invention, so that if a patent application can be filed for it, you can get that done before you disclose it. So then the final slide in the main part of the lecture answers another question that was in the chat earlier, which is someone asked, where are some good places to do searching for different types of rights? And we've given some examples of some good public websites here that you can use to do searching. Any of these will allow you to do international searching as well as searching in a specific country. The UK trademark one there at the end is UK specific, but the others allow you to do searching for lots of different jurisdictions. So if you need to do some searching, I'd recommend you start off by using one of those. There are lots of much more specialized databases that you can use, but they're not free. So these are the ones that we'd recommend. So finally, for the main part of the talk, we have a quiz which I think Verity is going to present, which runs through some different articles, and we're going to ask people what kinds of IP might exist in those articles. I guess maybe the best way for people to answer this is to put suggestions in the chat. Have you got the chat up there, Verity?
Yeah.
Great. Then over to you.
Okay, yeah, well, we thought, I mean, we'll just do a run through this quite quickly because we want to get onto your questions. But this is just, like Philip said, just kind of seeing whether you get the kind of different types of intellectual property we talked about, covering different products. So I'll just flash up a picture of a product or a thing. And could you just tell me any of the kind of intellectual property things that might be involved with this, so like any of the things we've mentioned. So it could be trademark, it could be a patent, it could be copyright, it could be design, unregistered design. So if you have any suggestions, yeah, I think the really obvious ones would be the Kit Kat logo. Everybody knows that's a trademark. Yeah. And in fact, Kit Kat tried to trademark the shape of their Kit Kat because that's quite distinctive, but actually they didn't manage to do that successfully. But yeah, yeah, there could be a patent in the manufacturing process of the Kit Kats or the packaging. There could also be, there is a slogan involved with the Kit Kat, so that's another thing that's kind of distinctive. Yeah, well, Kit Kat did try to trademark the shape of their Kit Kat, but they failed. They made a mistake in the kind of experiment that they had to do to prove that people knew that the Kit Kat shape was a Kit Kat, so they didn't get it. But Toblerone did get their shape of their chocolate. Yeah, time for a Kit Kat. I agree. Okay, next question. Oh yeah, there could also be copyright at the back of the packet. So at the same style thing, what might be involved in this chunky little luggage case? Anybody? Yeah, so design in the shape, maybe, because it's got these little horns. So the kind of cute animal shape could be design. Yeah, so design could be exactly. Design can be a part of any of the. It just can be to any of the parts of the product. So it doesn't have to be the whole shape. It could be the wheels. It could be, yeah, the type of handle or something. Yeah, there's a trademark on the name and to the design. Yeah, these are all correct. Yeah. I don't know if I put anything else actually. This one. Oh yeah, there could. I mean, patents can be for any kind of tiny invention. So there could be a clever zip on this. We don't know. There might be. So the next one is. What about this one? It's kind of going back to what Anna was talking about right at the beginning. Yeah, so copyright of characters is quite interesting actually. It can be done. And there's definitely copyright in the film and the poster. That's like an artistic work, what they've put together there. What about the kind of visual aspects of it? The appearance of their costumes. Yeah, and there's obviously a trademark in the name. Yeah, the font. Yeah, you could probably have a design in the type of font, I imagine. Yeah, it was really interesting. Yeah, so there's obviously trademark in the Spider-Man name. And the next one, just run through these ones. So this is quite an old Land Rover. We think it's probably over 20 years old. Yeah, so there'd be a design in a whole load of the parts of the car, probably, like the grille shape, the wheel shape, but any kind of part of the interesting part of the car. And then there obviously there's always a trademark for the logo. Yep, correct. And then I mentioned that it's probably 20 years old because that's how long patents last. And we imagine that there were patents involved in creating this car, but they've probably expired now. And that could be for anything. And then final question, what about this? Because I don't think we've really mentioned this much, but the contents of this finished tablet. Yeah, the formula of making the tablet itself could be patented. So kind of mixture of chemicals. We don't do that as much, but drug patents are a big thing. Yeah, and trademark on the name and packaging, and probably design for the shape of the tablet as well. Yeah, well, I think you guys got a good handle on the types of IP you can use for different products. So I think it's just, yeah, any questions basically.
Amazing. So it's always great to have a quiz at the end just to check if you guys are all listening throughout the talk. So Anna, Verity and Philip, many thanks for that. It was a brilliant overview on intellectual property rights, the definitions, the differences between copyrights, trademark, patents and design rights, and also the ownership and disclosure of IP rights as well. Great examples throughout the talk as well. And superb to see the interaction and the comments and the questions and the thoughts coming through in the chat. Philip has been answering these and posting notes throughout the talk as well. So in terms of obviously sharing these with you, I'll curate and I'll share the Q&A that's been populated in the chat at the end of the talk via email to all of the participants as well. And now what we'll do is we'll just spin through the questions and hopefully touch on those that haven't perhaps been answered. And if any of you want to go live and interact with questions and sentiments, feel free to do that with some general or more specific questions. And any of our guests, Philip, Anna, or Verity, you can feel free to choose to answer any one of these. So first and foremost, a question coming through from Tortbidas was, how will the NFT affect the IP industry? Will it make IP obsolete? As in theory, it could help to protect works internationally in a more simple way, perhaps.
Yeah, so at the moment, NFTs only have what you would call a basis in contract. So if you create a picture and then you sell someone an NFT that either embeds or links to that picture, there's nothing to stop someone else making a copy of that picture, except possibly for the fact that they've entered into some contract with you to say that they won't do it. And certainly some kind of third party who had nothing to do with your owning that NFT, they're certainly not going to have entered into a contract with you. So at the moment, NFTs are just something that provide rights as between people who choose to participate in that system. Whereas, let's take copyright, for example, that's the most kind of relevant one normally, because that is what you would have if you made a picture. That is protected by a legal right, and that legal right binds everybody, irrespective of whether they have chosen to participate in some kind of system that you might issue your NFTs on. So right now, there's no comparison really between NFTs and copyright, because copyright gives you a vastly stronger right. It's conceivable that in the future, maybe countries could legislate to recognize rights recorded in NFTs, but we're quite a long way off that, I think, because that would require essentially every country to sign up to that in order for it to be as effective as copyright is. So maybe in the distant future, it might be, it could have a similar effect, but right now I think we're a long way away from that.
Amazing. And then a question coming through from Adam Mahideen was, can you give someone your copyright? And Philip mentioned that yes, you can, or you can sell it. The other point here was in terms of the licensing. So perhaps could you expand a little in terms of how the licensing and royalties work?
Yeah, sure. So there are all sorts of ways that you can agree to grant a license to someone with the payment of royalties to you, and they're typically between at one end of the range, they pay you a fixed amount irrespective of how much they use the right. So they might pay you a fixed amount per year, and for that they can sell as many examples of the thing as they like. Or at the other end of the spectrum, you might charge them a certain amount per unit, and then the amount that you get back is entirely dependent on how many they manage to sell. So how people choose to apportion those two types of royalty bases, and there are lots of other ways of doing it, often depends on how they view the risk involved. So, you know, if I'm licensing it to someone and I'm not entirely certain that they've got the resources to sell as many products as I think the market could take, then maybe I would rather grant them a license on a fixed fee basis, because then it's down to them to try and sell as many as they can. On the other hand, if I'm licensing a massive tech company that I think can sell millions or billions of these, then I might be better just having a small per unit royalty, which could then add up.
Amazing. And the next question combines questions from both Michaela Roy and Tort Vides. So it's talking about the tools and databases that you can use to perhaps check for patents internationally. Patents that are both active and inactive or expired. So what portals or tools or databases would you guys recommend for that?
Would you like to do that one, Anna?
Yes. So for patents, we recommend using Espasnet, which is linked in here somewhere. Yeah, so this first one. And something to point out here is that when you file a patent application, it doesn't get published for 18 months. So that means it won't be in this database for 18 months, basically. So if you're, I suppose if you're working on something that's very cutting edge, and the likelihood is that everyone who's working on it is coming up with the idea around the same time as you, then if you've searched it in this database, you probably won't find it, because if they filed a patent application, it's probably been within the last 18 months. And so it won't be available on that website yet. But still worth checking. And for things that aren't published before you file your application, there's specific rules, because as I was talking about before, your invention needs to be new over everything that's been made public before. And obviously, if someone's filed a patent application 6 months ago, although they filed it before you, it wasn't public when you filed yours. So in that instance, your invention needs to be basically different over what's in the application that's already been filed, but it doesn't need to be inventive. So it gets a bit more complicated basically when the previous patent application hasn't been published before yours is filed. But apart from those, this website Espasnet is usually very useful.
Amazing, thanks, Anna. And a question coming through from Yusuf was, can you use the same name that of a company that operates in another country, and what are the implications if that particular company found out?
Do you want to get that one, Verity?
Yep. So first of all, I should mention that when you get a trademark for a name, you have to apply, you have to explain like what the goods are for. So you don't get the kind of universal, this is my work now, anyone using it is infringing my trademark. It has to apply to a certain like category of goods. So you can use the same name as another company wherever you are if it's a completely different kind of serious product or what's the word, kind of category of goods. So if you register a trademark, it'll be under a particular category like building work or something. And if you had a cake shop named the same thing, it wouldn't be a problem. But also trademarks are jurisdictional. So if you are in the EU and you have an EU trademark, then if you are kind of using the same name as somebody who's got an EU trademark, and you are kind of overlapping with the kind of products that you're selling, and there could be some confusion there, then you might get in trouble for using their name. But yeah, it does depend on whether the consumer is going to get confused between thinking that your company is somebody else's company. But also if it's in another country, then, and they haven't got a trademark registered in the country you're in, then you're okay for that as well.
Amazing. Thanks, Verity. And a question from Tortbidas. In terms of creators and startups, what amount of cash would an independent creator or startup require and need to put aside for their IP protections?
I'll answer that one. It really depends on what the nature of their business is. So, if I think about clients that we work for, in the first year, they might have a budget that's anywhere from £500 if they're just filing a design application to tens of thousands of pounds if they're filing a number of patent applications in the first year. So it depends what types of things you want to protect and how quickly the business grows, because the quicker you're developing things, the more things you'll have to protect in that first year. I mean, the best thing to do if you're setting up a business that might need that sort of protection is to speak to a patent attorney at the point when you're thinking of setting the business up, and explain generally what it is that you're planning on doing, and they'll be able to give you some advice about what a sensible amount of budget would be.
Amazing. And a question coming through from Ramsey, and it's more around the patent and the duration of the patent and the expiration of the patent, right? So after 20 years, the patent expires. How do you continue to protect those particular rights beyond the 20 years?
So that's a really interesting question. So Verity said earlier on that trademarks can carry on indefinitely provided the mark is still distinctive, but patents and designs don't last longer than 20 years. There are some techniques that people can use to try and retain some protection, and they're generally around making some ongoing improvements to the product so that at 20 years, the product that you're offering is maybe quite similar to the one that you were offering 20 years ago, but it's better in some respects. And those improvements have been protected by ongoing patents. So that at the 20 years, maybe it is possible for someone to sell the product that you were selling 20 years ago, but consumers won't want it because you're already selling a much better product that's under your new patents. So the way people, you can't, kind of directly answering the question, you can't retain protection for that invention longer than 20 years, but you can get effective kind of protection in the market for the product if you keep on improving it.
Amazing. And a question coming through from Iram: if a person has a similar invention and a patent in a different country, will yours still be granted?
Would you like to take that one, Anna?
Yes. So when I was talking about disclosures before, and sort of your patent application having to be new over every public disclosure that's been made before, that includes things that have been disclosed in other countries, basically. So if someone has disclosed your invention in France, but you want to file a patent application for it in the UK, you won't be able to get a patent granted because that idea is known to the public.
Awesome, thanks, Anna. And a question coming through from Iram with regards to the applying and reapplying for the patent if it's been rejected. What's the process like in terms of the due diligence, and if a patent is rejected, how would one go through appealing or getting it rechecked, or putting it a second application through for the same design?
Do you want to get that one, Verity?
I'll try. Well, when you apply for a patent, you go through quite an extensive back and forth with the patent office before it's granted. So, or not granted, but often there is something in your patent application that you can add to the claim, so the words that you're using to describe what you're protecting, that makes it grantable, so makes it new and makes it inventive. But if there is absolutely nothing in your patent application that could be used to get you a novel and inventive invention, then it will be rejected. And I'm not really sure if you can appeal it after it's been rejected. Can you?
Yeah, so you can, yeah. So in as Verity says, a big part of what we do as patent attorneys is advocacy at the patent office to persuade the patent office that the inventions that our clients have made deserve to be patented. So often the patent office will raise some objections, and part of our job is to address those objections, maybe make some changes to the application, or explain to the patent office why the inventions do meet the requirements to get a patent. If we can't convince the patent office, then the process beyond that varies a bit from country to country, but there's always some form of appeal from the patent office to typically a court that kind of oversees the way the patent office operates. There was another part to the question actually, which was about the level of due diligence that you need to do. So ultimately, there's nothing to stop you filing a patent, doing no due diligence at all, filing a patent application, and just leaving it up to the patent office to do some searching and seeing if they can find something similar. And that's a perfectly valid approach. The reason you might not want to do that approach is that there's a cost associated with filing the patent application. And often it's worth doing some searching yourself, or getting your patent attorney to do it before you file the application, just to make sure that you're not wasting money by trying to protect something that's already out there.
Amazing.
Could I just add something to that? I was going to say, I think the question also asked, can you file another application to the same thing? And the answer to that is no, because when you file your first application, it's published by the Patent Office. So it's therefore been made publicly available. And so then if you filed another application that was the same, your first application would sort of be cited back at you as evidence that the second application isn't new.
Amazing. Thanks a lot, guys. And a question from Kai Stopford. In terms of infringing intellectual property rights, like what are the implications, and what are how much would someone be charged or fined for this?
Yeah, so I gave a brief answer to that in the chat, but I can take this opportunity to talk a bit more about it. So the damages that you might have to pay if you're found to have infringed are generally based on what the loss to the owner of the rights might be. So let's take a simple example. Let's suppose someone's selling cars for the sake of argument, and you make a similar car, and the person who owns the rights calculates that they have lost sales of 200 cars, and let's say they make a profit of, well, it doesn't really matter what they make, you would look at what profit they would make, look at how many sales they've lost, multiply them together, and that would give you an indication of what the damages ought to be. So the idea is to put the patent of the patent owner or the rights owner in the same financial position that they would have been if you'd not infringed.
Amazing. Amazing. That's a really helpful answer. And another question coming in from Ramsey, and this pertains to logos and trademarks. In terms of the copywriting and trademarking, how similar, what's the level of similarities for it to be labeled as infringed or a copy?
You want to take that one, Verity, because that's quite similar to one of your slides.
Yeah. So for logos to be similar and somebody to be infringing your logo, then it needs to be there needs to be a likelihood of confusion. So it has to be the consumer getting confused between two products and thinking one of them's made by somebody else, like the kind of Asda penguin. So there was a penguin copy that Asda sold that people were getting confused with. They were picking up the puffin made by Asda, thinking it was a penguin, and so that was clearly too similar because they were losing out on business. So with logos and trademarks, it's about whether the consumer is going to be confused. And like Philip said before, if you're buying a really expensive product, you're going to be very careful checking that the product is what you think it is, and so it's less likely for you to be confused. But if you're picking up something like a penguin in Asda, you might not really notice it very much, and you might be more likely to get confused. So with trademarks, it's dependent on the consumer and what would they think. For copyright, Anna mentioned that kind of the similarities between them. Well, you can kind of take 11 words from somebody's literary work and be infringing on somebody else's copyright if it's the author's, if it's considered the author's own intellectual creation that you've taken, and that also kind of has to be substantial, has to be the kind of quality and not quantity of work that you've taken. So if you're kind of quoting somebody's song and you've used the kind of main key melody, then that's probably the quality part of their song, that you can't just kind of copy that. So the similarities are definitely dependent on the quality and how much of the work you've taken. With designs, it's really tricky with designs, like as I said, like it's kind of about what the overall impression on the user gives to the informed user. So it can be really similar and not infringe someone's design. It's all about what the informed user would think. So if that, with that example of the two kind of the chili bag and the ice bag, that person who uses those bags would really think they were the same, so they were similar enough to be infringing. So the similarities between them are all kind of slightly different, but they're all basically quite sensible. What would the person who was using them think? Would they think they were really similar, or would they clearly see the differences?
Amazing. And in terms of similarities and lookalikes, etc., there was quite a famous ongoing case recently between Colin the Caterpillar cake with the M&S, Marks and Spencer's, and the Aldi Cuthbert the Caterpillar cake as well, which was quite an interesting, obviously, story that went on for a while. I think resolved amicably in the last couple of days or so. So that's an interesting story that you guys can read up on. And the next couple of questions come are more geographic. Like, so Ramsey's asking, does every country follow the same set of rules to grant patents and design rights, etc., or does it do they vary from country to country?
On the whole, they're all very similar. There are some international treaties that set out some basic rules for how developed countries' patent systems work. and for the most part, there are really very, very minor differences between the systems. The biggest outlier in terms of developed countries is the US. And although it sticks to the rules that we've been talking about, there are some significant differences about how you can get patents in the US from the way it works, for example, in Europe, China, Japan, other countries like that. But on the whole, they're very similar.
Amazing. And then in terms of the patents database and stuff, does espas.net, .com, does it cover a worldwide patents, or are there more like specific databases for different regions like Europe and USA and stuff like this as well?
So that espas.net database does cover patents worldwide, and I noticed, by the way, someone had asked in the chat whether it's free, and it is free. A lot of individual countries' patent offices will have their own searching tools. So if you need to know some more specific data about, let's say, whether a patent in Sweden is in force, then you might need to go to the Swedish Patent Office's database to find that. Sometimes you get it on espas.net, but it will be more reliable to go to the individual country. And then naturally, there are more complicated databases with more data in that you have to pay for, which are the kinds of things that we would use if we're doing searching. But for general purpose use, these ones that we've listed here are really good.
Amazing. And then on a similar note, right, does the design register, is that more specific to the UK, or is there also one for Europe, Middle East and Africa as well?
So these two that we've listed here, there's a Europe-specific one, and then there's one that does other countries as well.
Amazing. Thanks a lot for that, Philip. And the next question coming in from Iram is, what's the craziest thing that you guys have had to patent?
Yeah, I saw that one, but I didn't have a chance to do some thinking about it. I think I've had to do some that have been what are called perpetual motion machines. So they're things where people think that they can generate energy forever out of this machine, and that's obviously impossible. So scientifically, those have been a bit odd. And then I noticed earlier on someone in part of the quiz, someone suggested that you might be able to get a patent for the Kit Kat recipe, and I've done one once on the recipe for a cake, which is fairly unusual.
Amazing. What about yourself, Anna and Verity? Anything interesting that's come your way over the last few years?
I don't think it was one that I worked on, but it was one that I read about that had it was gloves that you'd wear when driving, and they had some kind of haptic feedback element that would make you feel like you were holding a gear stick, but you just had this glove on, and it would kind of give you vibrating feedback to make it feel like you're using a gear stick.
Interesting.
Yeah.
And yourself, Verity, what's the most interesting one that you've come across so far?
Well, I haven't had as much experience as the other two, but I did do quite a cool one for a wave machine for surfers to ride on in I think it's in California, and it's one of the biggest natural wave machines ever, and that was pretty cool.
Amazing. And then what's it called? This is a super interesting question from Ride Cookcook, and he's talking about the design. Do you need to create physically, solve the design and create the final output before applying for a patent, or do you need to apply with just the idea and the concept itself?
So you don't have to have made it at the time when you apply to register it. You just need to be able to either draw a drawing of it for a design, or describe it for a patent.
Mm-hmm. Awesome. Another question from Iram, and I guess this is more institutional, and I guess probably got some aspects in terms of contractual agreements, but can you sue someone and get the design rights from a company, even if the patent was made within that particular company? So the design is yours, but they won't sign the rights over. What's the chances of winning?
So you mean the design was yours, but they applied to protect it when they shouldn't have done?
Mhm.
Yeah. So there is a legal process to allow you to get the rights back in that situation. And so if the rights are genuinely yours, then you should be able to do that. If the company that's wrongly filed this design contests it, then you'd have to take it to court, and that, although if you won, you'd be likely to get a substantial part of your costs back. You probably wouldn't get all your costs back. So there would be a risk that it would cost you something to take them to court in order to get the rights back. But there is a process to do it.
Amazing. And a question, I guess, the Kit Kat triggered this question. So a question from Oluseyi Abdul: can you trademark the style of chocolate with the 4 segments of the tempered chocolate? Would you trademark that? Would you what's it called? What design right would you apply for?
I think that's one for you, Verity.
I love my trademarks. Yeah, well, you can, in theory, you can trademark the shape of a product, provided that it shows, it kind of signifies the origin of that product. So with the Toblerone, you would just know that it came from Toblerone without needing to be told because of the shape. So with the Kit Kat, they did try and trademark the shape of the Kit Kat with the 4 fingers, well, the 2 fingers actually, they're just that snappable 2-finger shape. And I think they probably would have won, but they did the to prove that the shape signifies the source of the product, you basically do hold a little experiment where you sort of survey consumers and you say, here's this Kit Kat with no covering, doesn't say Kit Kat on it, where does this come from? And if people kind of give you the evidence that they know that that's a Kit Kat, then you can show that your trademark is serving its purpose. And Kit Kat sort of set up an experiment to survey people and get proof that people knew that the Kit Kat shape was a Kit Kat, but they left the logo of the Kit Kat on their chocolate bars when they did the survey. So it wasn't valid because everybody, even though they might have been just using the shape of the Kit Kat to distinguish it from other chocolate bars, the fact that it had the Kit Kat logo written on it meant that kind of made the whole experiment invalid because they could just read that it said Kit Kat. So they messed up on that one and they didn't get a trademark for the shape of the Kit Kat, but they theoretically could have done, and other people have done with different chocolate bars and other products as well.
Amazing, a rookie area there.
Indeed.
And another question from Iram: is it a regular occurrence for patents to clash, or is it very rare? And if so, like what industries does the clashes occur in most?
So I guess by clashing he means 2 people applying for the same invention at the same time. And it doesn't happen very often. I think it's probably quite surprising. It's surprising to me how infrequently it happens. The kinds of industries it happens in tend to be ones where different companies are working on very similar things at the same time. So for example, telecoms standards is one area where this happens a lot. So you probably know that when a new standard, so at the moment, for example, lots of people are working on more developments to the 5G standard. When they're working on that standard, they'll have a committee that thinks about how to develop that standard, and they'll invite people to make submissions. And everybody needs to put those submissions in at the same time. And you can imagine that if you've got lots of big telecoms companies working on exactly the same problem with the same deadline, there's a pretty good chance that they might come up with the same solutions. So that's the kind of area where it happens more. But in most areas of technology, it's quite infrequent.
Amazing. And the final question, guys, coming in from Ramsey, who's been on fire throughout. What happens if I've designed a logo or a design and it has no copyrights or trademarks, and that particular design or logo gets stolen or used by someone else? Will I be able to continue to use it? Can I sue for it afterwards? And I guess the other question there to add in as well would be, how do I prove that I was the first to come up with this particular design and logo?
That's a trademark one, Verity. Do you want to take that?
Yeah. Well, first of all, if it was a design with the unregistered design right, you don't need to have registered anything to cover your design. So as long as you have a design document, so that can be like a photo, it could be an email, it could be any kind of like a dated document that's got the design in it, then you can enforce your unregistered design. But then again, you would have to prove that somebody had copied it. So, but in this scenario, someone has copied it. So you might be able to use your unregistered design right. With a logo, you don't get a trademark automatically, you have to apply for it. So unless you have a registered trademark, you can't sue someone else for using your logo. Yeah, I think it's also about whether you're kind of losing business from someone taking your logo, and if you've just designed it, kind of have come up with a kind of pretty logo and no one really knows that it's associated with your product or anything, then you wouldn't be able to sue somebody for using it. But you might have copyright in your logo if you've if you've made like an artistic work. So, you know, you've got a painting of well, it doesn't have to be a painting, but you have some pretty logo that you've got. You could probably have copyright in that, so you might be able to enforce that. But yeah, I think you'd need to register your trademark for it to be enforceable. Amazing.
Thanks a lot, Verity. So I guess that concludes the Q&A. Anna, Verity and Philip, it was fantastic to have you guys this evening, and extremely generous with your time as well. So thank you for taking out your time and joining us tonight for both the talk, Intellectual Property for Designers, in brackets also, and engineers, so design engineers, product design engineers, don't feel left out, guys. It's all relevant to you guys as well, alongside the fantastic Q&A and the interaction. So the details of the talk were sent through to all of your emails ahead of the talk, including links to the Slingsby Partners website and the LinkedIn as well. So definitely feel free to browse and connect. To all of the participants and attendees who've joined tonight, so the staff, the students, the alumni, the guests, fantastic interaction and questions throughout. We really look forward to seeing you all again next week. So keep an eye out on your emails for the details of the speaker and the links to the next talk. And until next time, stay well, stay safe, and thank you guys.